Okay, I have waited 8 seconds for this to go live. I want to make sure everyone's there. And if my awesome moderator is in the house, make sure you leave a comment so that I can see that you're here and you're ready to join us also for a learning session, but to make sure that we're all doing this in a good way. Hello, everybody. Bonjour. My name is Pam Palmater, and I am the host of this YouTube live session. And I am so honored to be here. I'm from Eel First Nation. And in case you don't know who I am, I'm a lawyer. Don't hold it against me. A professor, an author, podcaster, and activist. Although, you could just say advocate. I don't know what the difference is. But that being said, I am going to be joined by three amazing warrior women, and we're going to be talking about the recent Supreme Court of Canada case that just came out on Friday. It's all the media is talking about. There's tons of questions all over social media, and I've been gathering up your questions. Thank you for sending them. And we're live. So if you join us live now or a little bit later, type up your question. We want to help answer any questions you have about this because we think it's really important that you have all the facts. So I'm going to bring on these amazing, wonderful people. First, we have Cindy Blackstock. Oh my goodness, she is one of my favorite people in the whole world. And I know I always tell her that, so I'm kind of a broken record, but she is just awesome. She heads up the First Nation Child and Family Caring Society. Her and Spirit Bear are best friends. They travel the country helping to educate Canadians about fairness and justice and equality for First Nation kids and families. And I just love the work that she's done. And she'll be able to help answer some of your questions. And if I have it right, you're from the Gitxsan Nation, right, Cindy?
That's right. Yeah.
Nice. Okay, so we've got one Mi'kmaq and one Gitxsan so far.
Yep.
All right, we're going to bring on Mary Teegee, and she is doing phenomenal work. I have never had the honor of doing an event with her, but here's the rule about doing events with me. Once you do it, now you've got to do more and more and more events. So
Okay.
you're hooked into this, Mary, and we're so happy to have you here. And if I'm not mistaken, you're from the Gitxsan and Carrier Nations, right?
Yeah.
Okay, so I feel very outnumbered. I've got 2 Gitxsan and 1 Mi'kmaq, so I better even this out. Oh my goodness. I have the most amazing Mi'kmaq person ever, Naomi Metallic. Anyone who doesn't know her, and I'm sure everybody does, she's a phenomenal lawyer. She's done so many amazing things. She's been to the Supreme Court of Canada, and I haven't been to the Supreme Court of Canada. So I'm just like so in awe of everything she does. She's from Listagouche, and that's literally my First Nation, Yorbar and Listy. We're like 20 minutes away from each other. We're literally so close, just almost like provincial border First Nations. Thank you for joining, and you too, Naomi. So you heard me talk about Mary. Once you do an event with me, you're in for life.
Over.
So thank you all for being here. I'm really excited, and I can see people are lining up live on YouTube. So that's great. Keep sending your questions once we get into the meat and bones of it. And so, Cindy, I wanted to actually go to you because some people were saying, hey, where did this court case come from? I mean, not everybody follows the law, right? The law can be kind of boring, and not everyone's on the media because the media can be a bit annoying sometimes. So some people are like, where did this come from? I never heard of this. But the issue in general has been a long time coming, hasn't it?
It's been a really long time. I mean, you think about it, Pam, before colonialism, it was First Nations, Métis, and Inuit people looking after their own children with their own laws. And then part of the colonial thing was putting the Western laws on top of those First Nations, Métis, and Inuit children. And often that meant separating them. Used the law to remove kids from residential schools. Then the 60s scoop. Then we had the provincial child welfare laws that too often just were a mismatch for First Nations, Métis, and Inuit kids, and that they didn't get really at their core problem that was driving the overrepresentation, the poverty, poor housing, the substance misuse that flows from that, and domestic violence. So we've had this whole trail of decades of mass removals of First Nations, Métis, and Inuit kids from their families. And there's been all this time, there's been different people in the communities and leadership and elders pushing to get our laws affirmed again. And I entered into it late in the game in 1997 when we were working on something called the Joint National Policy Review, which is a bunch of First Nations folks and the Government of Canada. We were documenting the underfunding of First Nations Child and Family Services, but our top recommendation was for there to be jurisdiction in Child and Family Services to restore those laws. Well, fast forward 21 years, and then the federal government decided to implement this thing called the Act Respecting First Nations, Métis, and Inuit Children, Youth, and Families. It's a mouthful, so no one really calls it that. We all call it C-92. But really what it does is sets national standards that anyone who's working with a First Nations, Métis, and Inuit child in Child and Family Services has to follow. Doesn't matter if you're non-Indigenous or Indigenous. And then it does another thing, and that is provides a pathway to affirm jurisdiction in Child and Family Services. Now, I want to just kind of give you a prelude because I'm hoping Mary's going to talk about this. This act, I think, has many good things, but the act that Mary and colleagues were working on for First Nations, I think, was far stronger. She'll tell you about that one, and hopefully we can pull some of the good ideas she's worked on there into this one. But the Quebec government wasn't very happy with this. And so they decided they would take it to court and say that, look, no. First Nations laws can't be over top of the provincial laws. We in the provinces look after child welfare. So our laws should stand, and the First Nations ones can't have supremacy, overrule basically the provincial laws. And then they put an argument about Parliament not being able to really interpret Section 35, which is the First Nations, Métis, and Inuit section of the Constitution that Naomi can talk a lot better about than I can. So this thing's been chugging along. There you got Quebec challenging all of these things. And then you had Canada responding to it. We were intervening. Naomi was our counsel along with David Taylor and Alyssa Holland and the Quebec Court of Appeal. She just gave it to them along with other Indigenous counsel. And the Quebec court agreed that most of it was constitutional, but there were two key sections, and Naomi will go over those, that they felt they were unconstitutional. So this all went over to the Supreme Court. And there we were again. Naomi was there again, along with David Taylor and Alyssa Holland, and acting for the Caring Society, and good old Spirit Bear was there too. The court heard it, and honestly, it took 14 months for them to make a decision. And I personally was worried. Like, I just thought, oh no, and let's face it, Pam, the Supreme Court hasn't always been very courageous when it comes to First Nations rights, right? But anyway, the decision came down yesterday, 8-0, which means the entire court voted for First Nations, Métis, and Inuit kids. So this means those national standards stand. And it also really provides a pretty strong pathway to jurisdiction for First Nations, Métis, and Inuit people. So it was a good day for kids. And a real credit to everybody who's worked on it for decades and decades before I was ever on the scene.
Well, that's fantastic. And I'm so glad that Naomi's here because she's like the superhero lawyer who's part of this amazing team.
Yeah.
And she'll be able to kind of get into some of the details. But Mary, I want to talk to you first because, long before this court case was ever a thing, this isn't a new issue for First Nations, is it? I mean, First Nations have been grappling with all of these child and family issues for a long time and wanting to have their laws and jurisdiction respected. Am I right about that?
Absolutely. And I think, to go right back to it, and the justices did reference this, what was the original intent of C-92? And that was really to stop the overrepresentation of our children in state and stranger care. We're the ones that are saying, we know what's best for our children. And in fact, We've always had the inherent right to take care of our children, but we know we just haven't had the resources to do so. So it's important to think about this again, this is a reaffirmation that we are able to draft our own laws and implement our own laws within the realm of child and family. But we also have to really be very, very mindful that I've always said this, we've always had the inherent right. We just haven't had the resources to breathe life into our own laws. So while we have this, we had a good ruling yesterday, there's still a lot of work to ensure that we're making the best decisions, and that we're ensuring that there are the resources to enact and to hold up our laws. And it's been something, of course, that we've been working on, for forever. Like, as long as I can remember ever getting into politics in my teen years. Just our right to self-government, that I am Gixon, I am carrier, this is my territory. And at the very heart of it, and I say this when I talk to especially young people, the simple definition of jurisdiction is really, really just your ability to make decisions. And as our leaders, as our parents, and our grandparents and our aunties, that's what they did. They made the best decisions for us as children, because we couldn't do that. We're just children. And then you think about all of the years of atrocities and the heartbreak of residential school colonization. We still inherently know what's best for our children. And so that's what this act reaffirms, really, is that our ability to make the best decisions for our children.
That's amazing. I mean, I think that point should have been made right from the outset. We've always known what's best for our families, all of our aunties and moms and grandmothers and all of the uncles and everybody that's a part of our family and community, all the elders, like, we know what's best, and just been interfered with for a long time.
Mhm.
And so I want to take us back a little bit, because there's probably people here on this stream right now, or who will watch it after, who has no idea what this court case actually said. So we know from Cindy that Quebec was thinking, you know what, we don't think we want First Nation laws to apply. We want our laws to apply, and we
Mhm.
don't think the federal government has jurisdiction. Okay. And, there was a Court of Appeal case, and then it went to the Supreme Court of Canada. So, Cindy has mentioned that it was a unanimous decision. Sometimes you don't get a unanimous decision. You get some who are dissenting, saying, no, we don't agree with that, or certain parts of it. So, Naomi, pretend I'm someone who knows nothing about this case and that I have not read the case. What's the core issues, the legal issues at play, and then what was the decision?
I did mute because the dogs are barking, but they're not anymore, so that's great. Yeah, not only is it a unanimous decision, Pam, it's actually written from the court, and often they don't do it that way. They'll put their names, who wrote it, and often there'll be dissents and or different judgments. And that's what I was expecting. Given the kind of questions that I heard, I thought there could be at least 3 or 4 different judgments, and I'd have to sort of figure out what happened by creating a flow chart. But I was really pleasantly surprised and shocked that it was from the court. Like, that sends an important signal to me, going back to Cindy suggesting that they were being courageous here. I think they were, and they were trying to say, because I think there's some different views on aspects of this, but they came together and they decided to give this the most importance, and to really show that they all supported the act and the purpose of what the act was getting at. They decided to do it as the court. So they couldn't have sent a stronger endorsement of this type of law is the kind of law that we need to address impacts of colonialism. They called it legislative reconciliation. And basically, I mean, the whole case was about Quebec attacking this legislation from a couple of different constitutional arguments. One being that the federal government just didn't have the authority to pass a law that could impact on people in the province, or provincial civil servants who are going to, agencies in Quebec who have to follow the national standards. They're trying to say, no, that you can't do that. And the court said, of course we can. Of course, like, under constitutional provisions, they found that the act in its what it was really about is about protecting Indigenous children and families. And they also said that you can't separate that point that Mary made and that Cindy made about, we know what is best, and the self-government component. all throughout the kind of appeals, Quebec especially was always trying to kind of hive that off and make that kind of a separate issue, and was even trying to like get the court to say, okay, maybe the national standards are okay, but the self-government part is a problem. And they said you can't separate them, and we refuse to see this as part one and part two of the act. They all go together as part of this comprehensive sort of approach to protecting Indigenous children. And they said actually the act is about sort of three things: these national standards, self-government, and recognizing UNDRIP. And they said all three go together, and they're all about protecting Indigenous children, and they work as a cohesive whole. So there was a really strong endorsement of the purpose of the act being that, and then them saying that that is completely within the federal government's ability under the Constitution, its powers and responsibilities in relation to Indigenous people under Section 9124 of the Constitution Act. So they said that is definitely okay. And they also just addressed some of the arguments that Quebec was trying to make. Quebec was trying to argue that the federal government wasn't able to recognize self-government in legislation, that this somehow amended the Constitution, because back in the 90s, there had, there was the constitutional attempt to pass the Charlottetown Accord, which failed, which would have amended the Constitution to specifically recognize self-government as part of Section 35. And anyway, Quebec was trying to say that you needed to amend the Constitution in order to recognize self-government, or you had to bring the type of case, a litigation in court, and you couldn't. The federal government couldn't recognize this in legislation, and the Supreme Court disagreed with that entirely and said, of course they can, and that's really key to this legislation. And this opens the door for all kinds of more legislation like this, where it's about implementing inherent rights. It's about helping set out frameworks for the exercise of it. And I think probably the thing that I think is well, there's a couple of things in this decision that I think are really, really important. One is that they accept UNDRIP. They accept that UNDRIP applies in positive law, and they don't even make a big deal about it. But they just start from that point, and that blew my mind. So there is definitely that. But there's also, like, if government can and is allowed to pass legislation recognizing the inherent right to self-government, and once they do, they are bound. They are bound by the honor of the Crown to act as if it exists. And and it binds them in how they're going to behave in the future. So it's like it's telling them you have to not just talk the talk, you have to walk the walk. And I think there's a lot in there, especially around the questions that are still remaining about how implementation happens now going forward, that we can draw on from this, because they really send a strong signal that the honor of the Crown is binding how the government's going to be acting and implementing this promise of the recognition of self-government. So I'll leave it there.
Yeah, it's hard not to get excited when Naomi's talking, right? It's like, it's the court. But, for non-lawyers, those kinds of things are really, really significant. And I don't know about you, but boy, the questions that I have coming in on social media are really, really smart questions. Like, people want to know, okay, well, that's great. Well, this is what the court said. Obviously, there's 100 pages of the court decision, but that's the most key part of it. But I've got some questions, and they have actually, all of you, different ones will go to you. I have one person. I have Robert saying, what impact does this have on the Canadian Human Rights Tribunal ruling? So, Cindy, I don't know if that's a you question, but maybe you can provide a response to that.
Well, I think all of us can kind of chirp on that one. Well, thank you, Robert, for your question. And as Robert probably knows, the Canadian Human Rights Tribunal still holds jurisdiction over stopping the discrimination in First Nations Child and Family Services, and also in Jordan's Principle. And they hold jurisdiction on a second question, is to make sure it doesn't happen again. That's the big piece that, like, residential school survivors and 60 Scoop survivors and youth in care want, is stop hurting us. So you know, we have been in front of the tribunal for now 17 years. And we have, it's been pretty much 8 years since the order. And we've had over 20 non-compliance orders, and we just filed another one last December, just in December, that just passed on Jordan's principle, which I want to take a shout out because Jordan's principle is actually mentioned in the decision.
Yes.
And that's a real honor to that little sacred spirit, Jordan River Anderson. So I think that decision, really, that walk the talk that Naomi is talking about, and the mention of Jordan's principle, I think that's really going to help us at the tribunal. And it takes away a bunch of the excuses that Canada always puts out there for non-compliance. But I think it's, I'm looking forward to kind of filing that with the tribunal and helping, you know, help support the kids' arguments more to get justice in that process.
Oh my goodness, Mary, what do you think? What could this possibly mean in going forward with that Canadian Human Rights Tribunal decision and Jordan's principle?
Well, I think like if you look on the ground, so I'm the executive director of Child and Family Services. So I work with the communities and I have social workers and whatnot. And when I say this, like, you know, and I don't mean to lose any of the honor and the strength of jurisdiction, but, you know, our ability to make decisions. And we had, you know, that's why we went to the CHRT, because of that inequity in funding on unreserved children. So we had like the, you know, great social workers, great staff, great community members, you know, building these great plans to protect that child, but we didn't have any resources or money to uphold those plans.
Yeah.
So when we think about C-92, you know, C-92, because, you know, both Cindy and I were in the legislative working group. You know, I drafted the AFN resolution to get, so that we could actually co-draft, and then it got changed to co-develop federal enabling legislation in child and family. So then we ended up going through to the National Advisory Committee, and they provided input into what that resolution should say. We went across Canada, we got input into what the resolution should say. And so when that got passed at the AFN, and then the doors were open to really push the federal government to draft federal enabling legislation, which then came to be C-92. One of the things that we were always really cognizant of, and you know, we said we needed a funding component within C-92, which we don't have. It's not a cost neutral process. So it was really timely because we won the Canadian Human Rights Tribunal in 2016. We had money starting to flow at 2018, 2019, sometimes 2020. And then we have C-92 in 2020. So it really was important that these two of you look at them. You have to look at them. If you're a leader, if a chief in your community, and you're saying, well, you know what, I'm going to go and develop my own laws as per C-92. Like but you also need to build that capacity to uphold the laws. So it's really important that you look at the funding that is provided through the CHRT, through those prevention funding, because, you know, that's what it is. We've always had our jurisdiction. We just haven't had the resources to breathe life into our own laws. So you have to look at it, I think, in tandem.
Such an important point, because, you know, sometimes you'll hear politicians say, oh, you can't just throw money at a problem. And I'm like, well, food costs money, water costs money, houses cost money, clothing costs money. So why is it that only when it comes to First Nations that resources don't matter? And I think that says a lot. And Naomi, I know you probably have something to say on this too, but one of the related questions is, are these two cases, the tribunal case and the Supreme Court of Canada case, related in any way? And I'm sure you have an answer to that too.
Yes. I mean, I think we don't have Bill C-92 had we not had Cindy's, you know, the Caring Society case, right? It's all about what led to this. And, you know, none of this would have happened without that pushing, right? That could have been perhaps elaborated on a bit more in the SEC decision, but, you know, and we did emphasize that as well. But like, you cannot lose sight of the fact of where this started and how we got here. And so the link between Caring Society and C-92 are so central. So they are linked. As I said, I do think they start to give us answers to or tools that are going to help us work towards actually holding government accountable on funding using the honor of the crown. We've been, using human rights a lot as well, but we need multiple tools, not just one set of tools. And so I think they help provide the groundwork for that. There are other decisions that are coming before the court. We're waiting on the Dixon case, so that's coming probably very shortly. But there's another case, and it's about the chronic underfunding of policing services in First Nations, particularly there's a community from Quebec. They brought a human rights tribunal case, and they were successful. That's being judicially reviewed by Canada. But they also brought a case in the courts using fiduciary duty and honor of the crown. And they were successful at the Court of Appeal using honor of the crown. So that's going to the Supreme Court now. But you kind of feel like they're sort of laying the groundwork here for bringing in this concept of honor of the crown and the obligation, the duty to implement promises. They reference that. And that's kind of the approach that was taken at the Court of Appeal. So I think these are moving together, and these cases are all related. And I think the judiciary is starting to get how chronic underfunding and how governments have been able to sidestep their obligations. And yeah, Cindy, so great that you mentioned Jordan's principle. I wish I'd remembered to say that in my intro, but definitely. And I think there's now a recognition that you can't, those kinds of maneuvers are not going to be acceptable. And they also, one of the part of the decision I think I just want to mention is just like, there's a recognition that the way that the legislation is framed allows people to go at their own speed, to do the capacity building they need to do, to take the steps. And so I really was happy to see that conversation about that in the decision. And so there's this pressure of needing to feel that you have to act and I think that's there a lot too, especially like, if we're going to have an election. But I think we now can have like a little bit of a sigh of like, we can take the time that we need. And also, like, governments are going to have obligations, even if, like, one government's mandate ends. Like, this is more than that. They are bound, honor bound now, and the court has really sent a strong message about that.
It's just so phenomenal. It's in so many ways, I can kind of see the web of things that this case can potentially impact in the future. But Naomi, before I leave you, I have a very technical legal question. Must be a lawyer, but Sarah is asking me, yeah, but what if Quebec uses the notwithstanding clause? So assuming that everybody here does not know what a notwithstanding clause is, can you kind of tell us a little bit about that, and then say, what if Quebec just says poo-poo on that decision?
Sure. So the notwithstanding clause is a section 33 of the Charter, which is part of the Constitution Act 1982, which gives governments the ability in certain cases with respect to certain charter rights. Section 2 and Section 7 to 15, none of which are about Aboriginal rights. These are all out. So Section 35 is outside the Charter. It's in Part 2 of the Constitution Act. And so basically, the notwithstanding clause allows governments for a limited period of time to say, despite these rights protections, we're going to override them without having to go through some of the other things that you normally would have to do, which is show that you've a justification. In any event, it doesn't matter because it doesn't apply here, right? So there, I want to put to bed any thought that the Quebec cannot rely on the notwithstanding clause here at all. End of story.
That's, what? Thank you, Naomi, because of all the questions that got asked on all my different socials over and over and over and over again, people were like, but yeah, Quebec's just going to use the notwithstanding clause. And one of the reasons for this live event is to just address these questions and make sure we have the facts and the law right. So that's fantastic for everyone who's watching. I have a question for you, Mary. Someone must know you because when I put the notice out that Mary, you were going to be on this, they were like, oh, tell Mary that I have a question. So they must be First Nations too, because they said, I work with some First Nations who were very nervous to enact their own laws under under C-92 because of Quebec's challenge. Do you think that now that the Supreme Court of Canada has upheld C-92, that more First Nations will feel like it's safe to go ahead and enact their own laws, I guess, as long as they have resources?
Absolutely. I think so. And I always, not to be a Debbie Downer, but I always caution nations to say, okay, and I always love this because Cindy always, like when she asked this question, a while ago, and she, well, Mary, what are the problems you're trying to solve with jurisdiction? And that's a huge, important question. And so there's this, and I know there will be a rush, like, oh, we got to get this in. Who knows what's going to happen with government, regardless of what we say. People are going to be cautious because we've never had this opportunity. When we get, even like, when we won the CHRT and all of a sudden we had money for prevention, it took a long time for our people to start spending it because they were so cautious, because it was like, what's happening? We actually have money for this? We've had $0. So I understand our people and the caution that we have, but I would say that, you don't need to be cautious. You could start developing that. But where you have to concentrate is to ensure that those safeguards and those services that our communities need for our children, to keep our children safe and thriving, they have to be there. That has to be priority. And I was just thinking about, what Naomi was talking about, the ability for us to sort of do that phase-in approach. When we were at the legislative working group working on this, one of the things that was really important to us was actually, let's look, and Cindy and I and the other part of the legislative working group really tried to bring the realities on the ground to say, okay, let's consider this. So for me, like, we have so many nations that we're providing services to, and we know some nations have, especially the ones that are closer to the urban setting, perhaps, they have more resources and more capacity and as compared to a remote community. So we had to say, okay, well, we need to push for this. We want to phase in approach within C-92, and that's really self-determination on the ground. So the leadership, the nations can say, well, we don't absolutely have all these services, so we can't really do, say, protection piece or whatever, but it's up to them that they have this phase-in approach. And I think if the listener is here to understand that you don't need to feel rushed, build your capacity, build those resources, and then get going. And one of the things that I often say is, and this has been right since I started in this role like 19 years ago, good practice makes good standards, which makes good policies, which make good laws. So even if you're not going down that path, still remember that those good practices that work for your community, start collecting them, make them into a standard, make it into a policy, because when you're ready to get your laws, you'll already have had that foundational work ready to go.
Wow, that should literally be a hashtag. Hashtag standards, hashtag policies, hashtag law, hashtag practices, because very succinctly, but that's so true. And that's also reassuring to hear, because a lot of the questions I could tell were coming from First Nations. And one, Cindy, was for you specifically, because this person works or heads, I guess, a child and family services agency, a First Nation one.
Yeah.
And she's asking, I guess, on behalf of anonymous other First Nation agencies, how this is going to impact them.
Yeah, like that's a really important question, because that's another place where the CHRT and this jurisdiction piece link. I think it's really, really important that people understand the level of trauma that's out there that the First Nations agencies are trying to address. Sadly, in many communities, the harms from residential school and colonialism are so severe. And we're seeing children with really high needs, a lot of them with substance misuse issues, or opioids, that kind of thing. And so these agencies have been on the front line of that and have just got the prevention resources to be able to do that. And I think that there's this reflex about, well, jurisdiction will fix all of this. So we'll pull out of the agency as a First Nation and we'll start doing it on our own. That would be, I think, a mistake. You need to have all of that infrastructure in place in the first thing. You need to make sure that there's someone there to hold that child's hand, to hold that family's hand in that time of need. And it should be a seamless transfer. with the agencies that are seeing they may serve multiple First Nations, and maybe one pulls out to be able to put down jurisdiction. Well, the federal government, in my view, should be there to support that agency to continue on with that good work. And one of the pieces we have to figure out is that if you're a First Nation, Métis, or Inuit government and you draw down jurisdiction, you are obligated to hold up those national standards in the Act. And you're also obligated to hold up non-discrimination under the Canadian Human Rights Act. So against persons who might be gender diverse or persons with disabilities, and then also the Charter. And so we need to make sure that within those laws, there's access to justice for the people, so that if the laws don't have the desired effect, aren't able to hold up the national standards, that there's a way for individuals in those communities to step forward and get some measure of justice. I think that's a piece that's still evolving, and the coordination of those laws within provinces and across provinces, that's something else that still has to be done.
Oh my goodness. Does it ever? And I think everyone's motto on this team is every child matters, no child left behind. We have to make sure no child or family is falling through the cracks of, is it the First Nation? Is it the First Nation child and family? Is it the provincial? Like, what's happening? So I think that's all of those are really, really important.
And we
I'm
might want to do a shout out to these people on the front lines. You know, doing child welfare is really hard. And, there's a lot of really dedicated and caring people working in First Nations communities all over this country and off reserve. And really, I just want to say thank you to those people, because I did that job for 15 years. That was the hardest job I've ever done.
I can't imagine. I can't imagine. I have someone here, clearly from Alberta. Jennifer, who is from an Alberta First Nation, says, okay, this case sounds great, but what if Alberta doesn't listen? And so I guess the underlying question there is, does this case apply to all of the provinces and territories, or is it just Quebec? Naomi.
All right, I figured. So this it's a national law, and it's supposed to, and it states that it's binding the federal government and the provinces. And so Quebec's big claim is that it couldn't affect them, and the court said no, it does affect. It does apply. It's national legislation, and it's intended to apply. So no, provinces should not be now trying to say, well, it doesn't apply to us. It does apply to them. That's why the federal government has the jurisdiction to do this, is to protect Indigenous folks from provinces. So this is part of the role that is being played by the Act. There's a little bit of language in the decision, and I haven't had a chance to fully consider it through. They do have a couple places where there's a conversation or like just a line about how to some extent, perhaps, to what extent can the provincial government be bound on self-government? And I think, and it's really not clear exactly what they mean. To me, I wonder if it's about funding, but it's a weird sort of line, and it's not given a lot of context. But you kind of got to consider it in the whole scope of the entire decision, which does say that this is federal legislation that binds all the provinces, right? So there's going to be some parts to figure out, and there is going to be bad behavior. Like, I think there's a lot in here that it's going to, so we can't just say, oh, it's perfect now. Like, there's still going to be provinces who are going to be rogue and going to try to push the envelope, I think. And unfortunately, like, I wish that wasn't the case, but we do have some, maybe some not good faith actors here. I think there's a lot to work with in the decision. There may be things that we then have to then mobilize behind and support and push back. I don't have a perfect answer for that. I think there's a lot to prevent the provinces from saying this doesn't apply, but there may be things that we may have to, again, look at, and there might have to be some fighting on, but there's a lot to work with. And I think there's a large network of us that are willing and, we're really behind any communities that are if they're going to be sort of backed into a corner on this.
I'll just add to that, like sort of the provincial piece. So, and I can speak to BC, and I'm definitely hearing this across the country. So in British Columbia, there's Bill 38 that was passed just over a year ago, and that's the amendments and act to support self-government, and it's an amendment to the Provincial Act. Now, one of the things that again, and I'm going to, again, being the Debbie Downer, be very cautious and be careful, because there's a fine line between jurisdiction and offloading.
Yeah.
And right now, as we know, so we won the Canadian Human Rights Tribunal. We were able to get prevention funding on reserve at the beginning at actuals. Now we have that money to actually do the work on reserve, and we're able to build that capacity. However, on the provincial side, we don't have the same resources. So where we have in BC, I'm just giving you an example, they have given the decision-making, or if you will, the jurisdiction to leadership and communities to make decisions when it comes to where children are placed, for example. Are they agreeing that the child, we can rescind a continued custody order? They can make these decisions, but there isn't any money that goes with that. So when Cindy was talking about, like the leadership, like there is that potential where our own leadership, because they don't have the resources, are making these decisions and deciding, oh, well, you're going to get this, but we don't have enough money for you. They're going to be put in that risky situation where they are discriminating against their own potentially, and where they're not able to meet the minimum national standards. So really have to be cognizant of these issues that are there. On the face of it, the act looks wonderful, but there's so many different layers that you have to look at. And one of the things I'm really concerned about is the liability that is going with making those child and family decisions in community and our leadership, where they don't have the supports or the expertise to make those tough decisions.
72% of kids in care are off reserve in First Nations communities. So that's a big piece, is getting those provinces, to do a better job.
Yeah, exactly. And we heard a lot of those concerns when it was Bill C-92. I was one of the ones that had some of those concerns, because insurance companies were telling me, well, we're not going to insure First Nations if they take this over, or the liability is too great. And so there was a lot of different characters having a part of this conversation while this court case was going on. Cindy, I have a question from Cindy, who says, I don't know.
There's another one of us out there,
Yeah, she says, I don't know if this is part of the Supreme Court of Canada case. Sorry if it isn't, but where are we with the foster care settlement?
Oh, that would be the compensation that came out of the Canadian Human Rights Tribunal. So where that's at is that the federal court has approved the settlement amount. But there's an important document that is being kind of drafted. It's called a distribution protocol. And that document actually has some really vital stuff in there about the supports for people who are going to be claiming it, and the process and how the money is going to flow. That's being taken out to First Nations leadership across the country for feedback. One of the pieces that I'm concerned about is that this is going to be a significant benefit, this compensation, to many, many people. But none of us are ignoring the fact that there are a lot of vulnerable communities, and there are vulnerable community members. The supports in the final settlement agreement are limited to cultural and wellness supports. That's good. But we also know our wellness people and cultural people are working 24/7 already. And we do need additional, I think we all need to be pushing the federal government as well as the provinces to ensure that there's adequate supports at the grassroots level across youth centers, domestic violence centers. All these different areas are going to need support, particularly over the first 3 years when this money rolls out. So there's a website, FN Child Compensation. The whole thing is being overseen by the class action lawyers now. The Caring Society is kind of finished our work at the tribunal, so we're not a part of the class action. But yeah, I think that that's something to keep an eye on for sure, because that money should start to roll sometime in the fall of 2024 is the current estimate. So
Okay, but
community should be getting ready.
there's a process, kind of like the compensation for Indian residential schools, Indian day schools, that kind of thing.
Yeah, but this is of a big magnitude, right? And so I think the support should also be of a big magnitude. And people should be starting to create community plans, emergency response plans. And if you have a small community, to maybe group together with your neighbors and create a response plan so that you're able to support one another, and make sure that service providers on the ground know that this is coming and then can prepare for that.
Yes, because sadly, there's always unscrupulous actors that come forward when they hear First Nations are getting settlements. So I'm hoping there'll be a lot of protections for sure.
I think the one thing, Cindy, too, a really important point to note for the listeners is that this is for federally children that were removed on reserve. And so the ones that have been removed off reserve aren't eligible for the compensation.
Yeah.
So theoretically, and I know a case that you could have like a family that had 6 children, 3 were removed on reserve and the other 3 were removed off reserve. So it's you know, when we say to get prepared, like the nations and the agencies and like all this information that needs to be out there, because I know I receive a lot of calls. I also receive calls from telling them, also you were removed, you're provincially billable, you're removed off reserve, so you're not eligible. That doesn't mean that there isn't another court case going, but yeah, it's something that's I think the listeners should know.
Yeah.
Really important. There's going to be we're going to have to do, in fact, another one of these, probably a lot longer, to answer some of those questions. And I do have a question, but I have to say, we have a senator watching, and Senator Kim Pate, who is also morally contracted to do events like this with me, and she does. She says, so grateful to each of you for your vital work and for this session. You are all brilliant and fabulous. Yay, Senator Pate, you're next.
Yeah, that's great work. And for people who don't know her, she's done a lot of work on the justice system and on other things as well, supporting First Nations, Métis, and Inuit peoples in a whole array of areas. But she's brilliant.
She is phenomenal. Now, Naomi, I have this question from Jack. And Jack says, when you were talking about the case, you said that the court mentioned that they recognized UNDRIP as positive law. What is positive law, and is this a good thing?
Yes, it is a good thing. They essentially recognize that the UNDRIP Act that was passed by the federal government in 2019 confirms that it applies in Canadian law. That's what I meant when I said positive law. Sorry, that's a bit of a legal term, but essentially that's what the court recognizes, that it applies in Canadian law. And there are different ways that UNDRIP applies. UNDRIP can apply as an interpretive guide to existing domestic laws, including Section 35, parts of the charter, or even a statute. There are ways to interpret the law so that it's more consistent. You could have 2 possible interpretations of something, and one could be more consistent with UNDRIP. So the fact that UNDRIP applies means that you should pick the interpretation that is consistent with UNDRIP. That's one way. The other way is the way that we see what C-92 is. C-92 is an effort to put into, to implement and put in practice the requirements around self-determination and the rights of families and the rights of children that are embodied within UNDRIP. So it's actually the government trying to pass laws to implement UNDRIP. So that's the second way. So what the court is affirming is that it applies both ways. In that, we use it to interpret existing law, but the governments are also using it to make new laws that are more consistent with UNDRIP. So the court's affirming both of those things.
That's awesome. And just so you know, there's comments being made from William. Thank you all for your conscious work. You've got people, Dark Native, saying, yay, this is great. You've got Jody saying 8-0 as if it was a hockey game, but that's a good reference. Yay, that's awesome. You've got like so many people here saying, oh, and we've got another one, Victoria King. We love you, Cindy Blackstock. We always get those ones. And of course, there's lots of hearts, lots of positive comments, people being really, really thankful that we're doing this a session. And of course, the questions keep coming in. And Mary, maybe I'll start with you, but I think I'm going to ask all of you about this because people are wondering, is there anything bad about this decision for First Nations?
Well, I think it, I don't know, like, I think it could have gone further on the Section 35 piece, but, you know, I think it could have been a little bit clearer on the paramountcy. But for all, like, I think, you know, as reviewing it again this morning on the plane, and, you know, and I was so happy, you know, Naomi was referenced in there, and just all the references, and it's just a good decision. I think, I honestly, I was telling you, like the night before, I barely slept because I really started thinking about the realities of what would happen. And I thought, do I really want to go? Like it's going to set us back, like, you know, years and years and years. And how long was it going to take us to get to this place where we have this ability to draft and implement our own laws? And I thought, I don't think I have the stomach or the backbone anymore if we lose, just that fight. So it is a really positive ruling. So I at this point, I'm just so happy that we got the positive ruling. That, you know, that again, you know, the only negative thing I think is that we have to ensure that, of course, that Canada fully recognizes it, fully, you know, takes this ruling to and fully implements it in its true breadth. And what I think the justices really wanted, you know, it is a really wonderful, like when I read it and you know, just how they really reference, you know, what was the intent of the act, right? So I can't say anything is super negative, but I just think that moving forward, we have to be very cautious.
Well, Pam, you're muted.
I've committed the gravest of errors. And it's so funny for everyone watching. I was typing saying, just leave your microphones on so we don't have to do the, hey, you're muted thing. And guess who did it? Pam Palmer. But just to say, we have Lita saying every child matters, every First Nation matters. So there's a lot of support here. Cindy, I'm going to ask you the same question. If you think that there's anything bad that might come out of this case, I know we've all just, you know, skimmed it. We probably haven't had the fine tooth comb yet. At least I haven't. But can you see anything that's potentially bad out of the decision?
Well, I just say with the Supreme Court cases that sometimes governments don't implement them. And that's been a challenge. We've seen so many good First Nations wins, and then the government just won't do it. And we've seen it in the Caring Society case at the tribunal with our First Nations colleagues, AFN, Kuan, and the commission. Like we've been trying to get them to comply. And what my experience has been is that Canada will violate the law. It will not abide by legal orders as long as there isn't significant consequences for them. And I think that that's the thing we have to watch. And something I said yesterday, this is good news, but nothing changed in the lives of children today.
That's so important to bring it back down.
Right down to the kids. And then the other piece too is that, you know, this idea of jurisdiction, it comes with the responsibility. And we can't just take over jurisdiction and mess it up in a serious way. It is possible to do worse, is what I'm saying. So we have to do better for our kids. And that's why Mary's caution is so important about taking it slow, making sure that you have the people on the ground to respond to those needs that I talked about, the poverty, the poor housing, the substance misuse, the mental health. And, you know, there's some other stuff. We got to embrace what hurts in our communities: sexual abuse, sexual exploitation, physical abuse, domestic violence. Those are real issues. So let's build up the capacity so those laws can really translate into children not only being safe, but children thriving in their families and being proud of who they are. That's the opportunity we have. So we have to treat it as if that's a sacred opportunity. And that means we have to do our due diligence and plan in a very strategic way so that our kids and families are set up for success.
Thanks, Cindy. Naomi, this was the second most sent question to me. It's, is there anything bad out of the Supreme Court of Canada case? Like, and I think they mean like legally bad. Is there anything that they said that's really hurtful to First Nations?
No, I don't think so. I mean, I think so. They took a different approach from the Quebec Court of Appeal, which did find. I mean, so the Court of Appeal said recognize a generic inherent right to self-government, particularly in the area of child welfare. But then they also sort of used that to say like the paramountcy provisions in the Act were unconstitutional because it didn't recognize the role of the provinces enough and needed to balance that. So this is an approach that is a bit different. So it doesn't go so. I said we don't have to decide the inherent right to self-government issue. Like, is it part of Section 35? But they do say we don't have to go there because on a reference, you really shouldn't go that far. You shouldn't create a bunch of more questions, which is what they were kind of suggesting the Court of Appeal did. But they said something else that's really interesting, though. They're like, Canada has accepted Section 35 as part of this act and self-government being it. And Canada cannot act any differently. It is bound now, unless it repeals the legislation, to act as if, it is real. And they even talk about that it is real because the federal government, it says it's real in the law. But they do say that, they also say it can be found under Section 35, or they don't go that far, but they leave us a lot of little breadcrumbs, which, for lawyers in the future to say, like, they do sort of suggest that they're, in the next case that might put this forward, that they it is likely that they're going to find it in some areas for sure. And the fact that UNDRIP is there, I think also will allow for thinking about that in new ways. And I think the same thing on paramountcy too, like they kind of marry, they sort of said like it's up to the judges. And so I know that your counsel was making some arguments that we can't just take the same approach. And I think I'm kind of more in line with Scott on that more than I probably was at the time. But I do think that there's got to be a bit of a different approach. But so I think they've also sort of left that open, right, to the future. And it's like making different arguments. But I don't think that those are like bad things. I think that there's pathways to those that are in the decision. I do think there's, like I said before, a little bit of wiggle room they've given the provinces that I'm not entirely I think it's narrow, but I'm not sure exactly what it means. That's probably the thing that gives me the most sort of concern. And it's just like a couple of throwaway lines in 2 paragraphs. And I'm a little worried how it might get like taken, but I think so more thought on that and more analysis on that. Like I'm trying to work it through in my head, but we know that provinces are bound generally by the act. So, there's more thinking on that, but there's nothing like obvious. But there's so much good, I think, that is in here too. And if I can make one more comment, that's something I haven't said yet. They use this metaphor throughout, and it comes from a legal text that John Burroughs and a bunch of awesome scholars were a part of. And it's called braiding legal orders. And they talk about how we are now in sort of this time where reconciliation means braiding Indigenous laws, UNDRIP, and state laws all together, and that they have to be sort of harmonized together. And that's like groundbreaking. They have never gone so far as to suggest that that's what reconciliation means, and they see C-92 as part of that. But I think it also, come to some of the concerns that Cindy was raising, like UNDRIP really emphasizes the fact that human rights, international human rights, have to be respected too. So it's really presenting, I think, interesting frameworks for now thinking about how we're moving forward with these different legal orders coexisting together. And it is a lot of work that we're going to have to do to figure that all out, but sure is exciting.
It is exciting. We have about 2 minutes left, so I want to give you each a minute to kind of think about what could be next steps for everybody involved. Cindy, what do you think? What's next step?
Well, our non-compliance order is percolating along at the Canadian Human Rights Tribunal. And Canada, before this decision, was opposing us. And we have hearing dates on June 3rd and 4th. I think it's going to be interesting to see if they actually step in line. That'll be an early indicator of whether they're really serious about walking the walk. And for everybody, just go to fnwitness.ca. You can keep up to date on the tribunal. And I'm sure, you know, Pam, we're going to have to come back and talk to people about that noncompliance.
Oh my goodness, yes. Just a one-off on that one. What about you, Mary? Next steps?
Well, I think there's next steps on, like, with my agency and my nation. You know, we're just going to continue the work that we're doing in drafting our own laws. And I guess you know, it's really to ensure that Canada is, you know, fully implementing the case here. But I always think that you know, and Cindy says this, you know, well, how did the children's lives change today? But just to really step back and remember, why was this act created in the first place? And that was to better the lives of our children and make sure that we don't lose any more of our children. So the next step is really to think about how your own traditional laws did that, and to start collecting that, you know, start writing them down, start doing, you know, start doing that work, collect all the best practices that you know that works in your community. And I think those are some of the next steps, because at the end of the day, we know that positive change or negative change, when there is significant change in administration and a reorganization, that's when children fall through the cracks and ends up in child death. We know the research has shown that. So when you're transitioning from you know, provincial law and you're going to your own laws, you got to make sure that's seamless. You got to make sure that what you're practicing now is the way you're going to practice when your own laws are enacted.
Yeah.
Such important advice. No one can fall through the cracks. Naomi, next steps?
For me, like, personally, I mean, I think I love this idea of these braiding of legal orders, and on Mary's point about, you know, how important reconnecting with whether we call them traditional laws, but are Indigenous laws, but working with, you know, there is some amazing work, and shout out to the Wekotowin Lodge and Hadley Freeland and Corin Lightning Earl, but they're doing some great work to help communities actually draw out laws that are legitimate based on their stories and their language and their practices. And so there's some great work that you can actually, like, bring these folks in to kind of help communities sort of think about ways to reconnect with those laws if they're not, you know, if you're not connected as much with them as you'd want to be, and how to work them in, because I think they're so key. Because again, we knew how to do this, right? And we had some wonderful ways about taking care of our people, and it's so important to reconnect with that. So I'm really excited about seeing the work that will fuel this work, as well as bringing in and braiding in UNDRIP. And that's I've been working on that on a PhD, but like how UNDRIP is the framework, and working like things with like international human rights standards as a basis, along with our Indigenous laws, to sort of see the way forward. I'm really excited about all that.
Well, it looks like we've got a lot to do. It looks like the viewers, you've got De Quincy saying thank you for such an informative discussion. We've got more love from Mira. We've got thank you for hosting an enlightening and informative discussion. Make me feel optimistic. We're trying, you know, that we know all of the bad stuff that's out there, but we're trying. Harmony's saying you're all amazing. TJ's saying thanks for making this accessible, which is what we were trying to do. So this wasn't a legal discussion per se. This was really just trying to make it accessible to people who are not lawyers or whoever doesn't read court cases. And we've got JM saying I'm cautiously optimistic, and JM again saying love to see it. So thank you all for taking the time out on a Saturday night to join us live. Tell all your friends, family, community members that this will be live or sitting forever on YouTube. You can watch it. I'll make sure to put it on my podcast. We'll probably do a part 2, maybe a part 3, 4, 5, because they're all contractually obligated to me now. So I'm gonna get Naomi for UNDRIP. I'm gonna get Mary for the practical, and Cindy, you know, we've got to talk about this non-compliance. And if Senator Kim is still on here, we are going to do another one on over-incarceration and the wrongful prosecutions of Indigenous women. Thank you, everybody, for caring. Spread the word. We've got this in hand. First Nations and Indigenous peoples, we never give up. We're we're going to win all of these little wins. We need to celebrate everything in between. So thank you again. Thanks all of you, Cindy, Mary, and Naomi. I can't wait to do this again.
Thanks so much, Pam. Thanks,
you.
Naomi, Mary.
What an honor.
Palalio.